Good afternoon. I'm Sylvester Johnson, Director of the Center for Humanities at Virginia Tech, and I want to thank you for joining us for today's Faculty Research Colloquium. I want to thank Joe Ford, who directs the Athenaeum, the Digital Hub at Virginia Tech, and Dominique Francesca, the Business Manager for the Humanities Center, for their work in making this event possible. And I want to give a quick reminder that at the same time on Monday, March 28th, Professor Maria Armstrong will present her work on Black theology, blood, and the literary work of Pauline Hopkins. Now, for today, we are joined by Professor Sharon Johnson. Dr. Sharon Johnson is an associate professor of French in the Department of Modern and Classical Languages and Literatures. She directs the Women and Gender Studies program. She's a 19th century French scholar, and her articles on Paris and Émile Zola have analyzed the manner in which medical, political, and literary discourses constructed and conflated disease and immorality and impropriety when depicting 19th century Paris's urban problems and its working class. She's currently writing Bodies That Speak, narrating and interpreting rape in law, medicine, and the penny presses of 19th century France. This book project examines representations of rape in legal, medical, and journalistic discourses. And so she'll be sharing some of the research that she has developed from that book project. So we're very delighted that she's joining us today. And I want to remind all of our audience members who are watching that we will invite your questions and comments about half past the hour, about halfway through our program. So you can send those to us at any time. If you click that Q&A button at the bottom of your Zoom window, feel free to send us your questions or comments at any time, but we'll pause about halfway through in order to get those questions and comments from you. So without further ado, Sharon Johnson. Thank you very much.
Well, thank you very much, Sylvester. And I would also like to recognize Randa, Dominique, and my department for this honor of being a research associate at the Center for Humanities this year. I would also like to thank my colleagues, my students, friends, and family out in cyberspace who have come to hear my work today. So before I present my actual paper, whose title you see here, I'd like to give you an overview of my research from which this paper is taken. So trials, which is what I'm going to be talking about today, or cataloging crimes at the National Library of France, usually was done by the name of the perpetrator. You see here in the image, the convicted criminal, the priest Joseph Contrafatto. And this is no different from the corpus of my sensationalized news stories that were printed as separate broadsheets and pamphlets, penny presses during the long 19th century from 1827 to 1909. As you see here, what I'll be presenting you today is from my 7th chapter of my soon-to-be completed book. Unlike Balbir Singh's book, who presented so wonderfully last week, my approach is more kaleidoscopic, where in each of these chapters that you see here are separate essays that take on various dimensions of analysis of the narratives of these penny presses. In my corpus of, hold on. Oh, yes. Oh, sorry. In my corpus of 116 canards sanglants, sensationalized newspapers, these are 4 block wood prints and lithographs from different stories. Sadly, in my corpus, most victims were also murdered, which in part explains the title of my book, because it was not the victims actually who were speaking, but their bodies, which bore witness to the perpetrator's use of force and violence. I have been working on this project for more than 10 years. And you might ask, why so long? Well, there are two reasons I'll present. The first is rape is an invisible, silent crime that few sources report on or represent. And the victims themselves often do not report what has happened to them. This was true in the 19th century, just as much as it's true in the 21st century. So the only way to find extant documents are in the archives. Working in the archives, this is the second reason, is a very slow, fastidious process that most scholars cannot appreciate because they haven't done the work. They don't understand that it entails, the work that it entails to basically create your corpus. For example, it took 5 years for me to find the 3,300 canals that I looked at, from which 116 reported on the crime of rape. I had to go to 4 different libraries in Paris, and I also relied on 2 scholars' research who have published on these newspapers in the 1950s and 60s, so a while ago. I also want to mention and express my gratitude to my College of Liberal Arts and Human Sciences, my previous College of Arts and Sciences, University Libraries, and the Peace Center and Violence Prevention Program for the grants that I have received over the last 10 years in support of this research. The format of my corpus is highly variable. They can be 4-page pamphlets, 8-page, 12-page, 16, 22 pages. If you look at the 2 canals sanglants to the left, both are 8-page narratives. And what really happens, at least in France, sort of like zines, if you know how zines are made, is this is an actual broadsheet. You can see it's an A3 size, for those of you who know European standards. So to have a 4-page document, you just fold it in half. 8-page document, you fold it again in half, and then you cut the edges. So the one broadsheet represented here is to the right, and it is pretty typical of the broadsheets that are in my corpus. That is to say, you have the title up on top, and you'll notice the very small writing, which is a summary of the main points of the narrative. And then you have a lithograph or a wood block print that covers about 1/3 to 1/2 of the page, and either 2, 3, or 4 columns of text. The first 2 or 3 columns are of the actual crime, and then they close with a poem or a complaint, a poem in verse, and they always indicate a tune of a song to which it would be sung. And what I want to show also with these 3 images is that they all are in sync or representative of the actual crimes on which they were reporting. This is not always the case, as you see here. These 2 canals sanglants, also 8 pages in length, were recycled for multiple crimes. They were stock images then. And we note here, however, that the publishing house was the same, Maison Aubert Baudot, and both were published in northern France within the same time period of 1880 to 1882. And lastly, I love this particular image because it captures the hawking, singing, and performative elements that were involved in the 19th century when these sensationalized newspapers were sold. And I have to say that these are different than periodicals because they only were printed when heinous crimes or important events transpired. So they aren't in any journal or newspaper. So as you see here, a large crowd is gathered. The person selling the canal sanglant is the woman and the man. He's probably singing the poem to the familiar tune. The woman on top of a box is pointing to the images that are on the broadsheet. And you can also see the materiality of them. They are folded over on her arm and their young child's arm. As rape was always depicted in these canards sanglants and in French law as a barbarous, heinous crime where punishments were very severe, the reality is they were tolerated and punishments were often light or did not happen. But what interests me about this particular corpus is that is being sung to catchy tunes and having the titles shouted out, which would have challenged dominant ideology of accepting rape as natural. And I imagine the crowd going home with rhyming snippets of the songs, and that could perhaps change their way of viewing the crime. So today, as I said, I'm going to be presenting on one trial and doing a very close analysis of it, which is why I'm going to be reading my paper. Though the topic of rape can be very triggering, and I have to say just hearing the age discrepancy between the perpetrator and the victim is harrowing. There is no specific violence of the crimes that are in my paper. And lastly, I take responsibility for the quick translations. So, the Contrafatto affair, law and narrative. Writing about the crime of rape details emotional and psychological suffering and or physical violence that the victim has painfully endured. On October 15th, 1827, the 28-year-old Joseph Contrafatto was sentenced for raping 5-year-old Hortense Lebon. Today, I will be analyzing especially the rhetorical strategies used by the prosecution and the defense. This is the first study to examine the 58-page trial document, generally speaking, and specifically within Robert Cover's legal framework articulated in his Justice Accused. Cover's legal reflections allow us to appreciate the prescience of the prosecution's innovative arguments concerning future legal modifications to Articles 331 and 332 of the Criminal Code. Moreover, the code's omissions and unclear language also contributed to rape penology's changes over the century. French jurisprudence would come to include la violence morale, or this does not translate in English, moral violence, a type of coercion or abuse of an individual's trust or naivety, and the requirement of consent as parts of the rape statutes concerning minors in 1853 and adults in 1857. The Contrafatto affair is a rare document. Just like my corpus, in modern Europe, only 1% to 2% of extant judicial documents were on the crime of rape. Reasons abound for this low percentage. In addition to those I mentioned earlier, women and men did not come forward about their rape, in part because victims were often ill-treated in judicial courts. The plaintiff's line of reasoning were used against them. Victims were blamed for their assault or were not believed, and minimal to no penalties were assigned to the perpetrator. Moreover, medical legists saw women as inferior to men. And lastly, women or their families also experienced social shame, such as loss of their honor, or social sanctions were imposed. This has been true in France since the Middle Ages and was representative of the 19th century. Both lawyers' closing remarks represented two different approaches to interpreting Articles 331 and 332 of the Criminal Code. Their legal tactics also demonstrated a rather parallel situation that Robert Cover advances in Justice Accused, where he argues that in a dynamic model of law and judicial process, quote, the law is always becoming, and the judge has a legitimate role in determining what is the law and what it will become. The flux in law means also the law's content is frequently unclear, end of quote. In the closing remarks of the prosecution, lawyer de Vauffreland elucidated that Article 332 lacked clarity. He guided the jury and judge to think more broadly about the intent of French law, arguing for novel understandings of the rape code. Lawyer Saunière for the defense argued his case narrowly, using jurisprudential precedents. In Justice Accused, Cover studied white society of the antebellum period of the United States, beginning after the War of 1812 and ending with the Civil War that broke out in 1861. Contrafatto's 1827 trial occurred during this almost 50-year time frame. Cover analyzed prominent judges' decisions who enforced the fugitive slave laws, yet who privately sympathized with the abolitionist movement. Martha Minow, also a legal scholar, argues that Cover showed how the judges, at least before 1850, could have forged available legal materials into arguments abolishing slavery. Instead, Cover found that the lawyers felt powerless and bound to interpret the statutes by the letter of the law, as Minow underscores. The judges treated the matter as if law simply specified rules of the game, rules that narrowly specified the judge's own latitude for action. Accordingly, a judge simply could not do other than enforce the fugitive slave law. To do otherwise would fall outside the judicial role. Minow continues, quote, as a result, an influential group of judges tended to respond with avowed helplessness and exaggerated formalism. They acted as if they were followers of the legal system rather than innovators, obedient servants to the law rather than the leaders, end of quote. The lawyers in the Contrafatto trial fell into two camps a la Cover. The prosecution proved to be leaders and innovators in the arguments they put forth to the jury and the judge. They employed reasoning and language that one finds in future rape criminal codes, while the defense proved to be an obedient servant to the law using greater interpretive formalism and rigidity. Both sides based their arguments on Articles 331 and 332, wherein the word assault, attentat, was used instead of rape, which euphemized and attenuated the seriousness of the crime. So I rarely use the word rape in this paper to respect French law. Article 331, a non-violent, indecent assault, which is a horrible translation of de l'attentat à la pudeur sans violence, stated that special considerations needed to be made for minors under the age of 15 in 1791, 11 in 1832, and then 13 in 1863, as, quote, there is a presumption up until this age that the agent has taken advantage of the children's ignorance to stigmatize or corrupt them, end of quote. In Article 332, a violent, indecent assault, de l'attentat à la pudeur avec violence, as the criminal classification affirms, the perpetrator must use physical violence during the sexual assault for it to be considered rape. There were two lawyers arguing for the prosecution, lawyer Ledru, Madame Lebon, or Mrs. Lebon's lawyer, and lawyer de Vaufrelon serving as the king's lawyer. The attorney for Contrafatto was lawyer Saunière. Lawyer de Vaufrelon defined his terms as to what constituted violence in plural. He argued for a broader understanding of that concept. It should not be limited to a perpetrator's violent physical acts when committing sexual assault, nor should it be limited to the victim's effort to fight off her assailant. He wished to problematize this narrow application of the law because Hortense did not scream. She did not resist. The accused did not need to use any violence or force to rape her. The prosecuting lawyer, with ingenuity and sagacity, expanded the legal definition of violence, stating, quote, in the law, in absolute terms regarding violence, it included moral violence, end of quote. His reading was as follows. With regard to the young Hortense, does her situation not result from the extreme influence that an older man of the cloth exercised over her, and from her reverential fear and respect for the personage of a priest? Her assault was established by the testimonies, and Mrs. Lebon's family had instilled in Hortense to revere the priesthood. When a priest abused his authority against her young age and character, it is impossible that she even thought of resisting his advances. Lawyer Saunière argued for Contrafatto's innocence, advancing a narrower understanding of attentat à la pudeur avec violence, Article 332, with the legal statutes based on the 18th century attorney Merlin's definition of violence. He also expanded on Merlin's judgment to respond directly to the king's attorney's line of reasoning. If that violence was not absolutely physical, if it was not used against the person of young Hortense, there is no violence in the legal meaning of the term. Moral violence is really only a kind of corruption of the statute. Physical violence is nothing other than the means employed to overcome the opposing resistance. It is impossible, by admitting that there was an indecent assault with violence, to declare that it took place with the help of violence if there are no marks. When lawyer de Vaufrelon argued that Hortense Lebon had experienced moral violence, it was a position that had come up in other court cases regarding Article 331. However, moral violence was never included as a defining element of 4 different changes to that statute over the course of a decade, when young children were assaulted or raped, and there was no sign of physical violence. Therefore, there was not a legal precedence in that included moral violence in the code at the time of the Contrafatto trial. A real gap existed in criminal law, as lawyers Chauveau and al. Argued. It is certain that most of the attacks committed on young children are not accompanied by physical violence. They are all the more odious because a child's will is corrupted to accomplish them. By this corruption, which indeed exercises a kind of moral violence on their minds, on their chaste thoughts, on the purity of their childhood, differs essentially from material violence. It is a distinct action, another criminality. The gap in criminal law was not fixed until 1853. As such, lawyer Saunière stated categorically that moral violence did not represent material violence, legally speaking. Yet, As Chauveau et al.'s opinion recognizes, child victims of nonviolent indecent assault rarely endured physical violence when sexually aggressed. They labeled this phenomenon as, quote, a type of moral violence, end of quote, representing the same premise de Vaux-Frelon advanced and that future courts would modify. Two other gaps in French law existed that were changed in 1832 regarding the age of statutory rape and imposing a penalty on the perpetrator if convicted of a non-violent indecent assault. From then on, an attempted or consummated rape was punishable by criminal detention when a child rape victim was younger than 11 and her body bore no detectable signs of physical violence. At the time of the trial, in cases involving both articles, the court could not incriminate a perpetrator of rape without proof of physical violence. However, in the 1820s and 30s, judges and lawyers began to interrogate the different forms of violence regarding rape. They pondered, quote, should the brutality of rape, undefined by the code, be exclusively physical for it to be considered criminal? End of quote. Two decisions in 1828 and 1829 temporarily sidestepped that issue by giving the judge absolute authority to decide what violence constituted in the cases of violent indecent assault. It was in 1885 the courts ruled on those omissions, that is, on the notions of consent and moral violence, as we see in this report from the newspaper of Tribunal Affairs. In truth, in the silence of the law, on the character of this violence, one can admit that physical violence is not essential, that moral violence is sufficient. De Vaux-Frelon's first argument underscored that Hortense Lebon would never have consented to being raped. Hence, moral violence was at play. This newspaper's definition followed de Vaux-Frelon's line of reasoning. If victims could not consent to their sexual assaults, the court's verdicts must conclude they were raped. Whereas moral violence usually did not suffice to win a rape case in the first half of the 19th century, it came to be seen as an integral part of Article 332 from 1855 on. De Vaux-Frelon was a leading legal thinker in the first third of the century when arguing for a broader legal definition of violence. De Vaux-Frelon's final legal argument advanced that Hortense could not have consented to the two rapes she endured. He adeptly returned to and nuanced the contention to make a stronger case for a violent, indecent assault. He intertwined law with morality by reaffirming that the victim experienced moral violence. He was categorical, quote, where there is consent, there is no violence. But where there is not the possibility of consent, violence occurs when carrying out the rape, end of quote. He used this innovative framework suggesting law's ethical intentions. It is a result of these reflections that it is easy to conceive that Article 331 and 332, there could never be violence exercised when it comes to children as young as the one we are dealing with at this moment. Horrible, consummated sexual assaults on these children could never be punished. The law could not have wanted it so. The law did not specify, in speaking of violence, that this violence would be of such and such of a kind. It made no distinction. Therefore, there is only subtlety in the system of defense that you have been told. As we have seen, lawyer de Vaux-Frelon identified two legal gaps that future court rulings modified. Without legal precedents, he called upon the jury to use its wisdom in love for justice to declare that moral violence occurred. By underscoring that Article 332 did not specify what kind of violence was necessary to prove the case of rape, that omission paradoxically provided an opening to expand the intent of the law. Textually, in 2 short paragraphs in the trial document, and in real time during the trial itself, 15 minutes, the jury returned to the courtroom with its judgment. Contrafacto was found guilty of attentat à la pudeur commise avec violence in the plural, indecent assault committed with violence. Contrafacto heard his sentence with numbed dejection. The judge's terminology that Contrafacto violated the child's trustworthiness indicated that he believed de Vauxfrelon's argument. Hortense could not have given her consent. He also used the legally nebulous term brutalités, brutalité, to characterize Contrafacto's violent acts. Contrafacto was condemned to a life of hard labor and the branding of the letters TP for travaux à perpétuité. This conviction was the harshest the jury could impose after the death penalty because it sentenced the criminal to a civil death. Law restored order through narrative. The victim's testimony and her lawyer's closing arguments rang truest with the jury. De Vauxfrelon took on the responsibility to question a narrow interpretation of a violent indecent assault on a child younger than 15. Arguing Hortense Lebon's lack of consent in this trial was also an innovative argument, as it was not included in the legal language of Article 332 in 1827. Moreover, it is remarkable that the jury and judge believed Hortense's testimony was truthful. In old regime France, through the 19th century, dominant perceptions existed regarding rape, wherein a man's brutality would be excused, that is to say, not come to trial before it was even judged. Other circulating ideas were women had a diabolical lasciviousness, women gave themselves over to rape voluntarily, resolute women had the means to fight off their offender if they wished, and consummated rape would be consensual rape. Moreover, a woman, and therefore a 5-year-old child, were not seen as subjects in their own right, so their testimonies were not typically considered believable, especially compared to those of a man. Minot submits that, quote, according to Cover, the availability of multiple judicial settings offered a check against errors, a guard against bias, a challenge to ideological blinders, and an opportunity for innovation. This rape trial had a revolutionary interpretation of Article 332 that influenced a judge and jury to concur that violence in this case meant moral violence, and there was a lack of consent on the part of the victim. This is a perfect example of what Cover would consider moral and legal innovation. Moreover, as we saw, Articles 331 and 332 of the Criminal Code contained several gaps and undefined terms. For Cover, that lack of clarity, quote, makes possible ameliorist solutions. The judge may introduce his own sense of what ought to be interstitially where no hard law yet exists, end of quote. On 3 separate occasions, 2, 30, and 50 years after the Contrafacto trial, the courts modified those 2 articles. The 1827 trial was an extraordinary case in terms of rape legislation. The prosecution's closing arguments were brilliantly forward-looking. French jurisprudence would come to include moral violence as a constitutive part of the rape statutes concerning minors and adults by the 1850s. When accusing a rapist of having committed a violent indecent assault, rape victims' bodies no longer had to bear material physical violence to prove a rape occurred and to convict the perpetrator of that crime. As Covert argued, when law and judicial process represent a dynamic model, legal statutes are always evolving. Contrafatto's trial, within the context of 19th century rape penology, demonstrates how France's 1810 criminal code changed as differing interpretations and social understandings of rape modified French jurisprudence throughout the century. Thank you very much.
Thank you, Professor Johnson. Those were really very moving and insightful analysis of some, I would say, difficult material, but very important to understand some of the history of how sexual violence and sexual assault has been treated in this literature. So thank you again. And we want to remind our audience, we welcome your comments and your questions. So if you are in the Zoom application, you can simply click that Q&A button at the bottom of your Zoom window and send us your comments and your questions. And I have a few questions here already I'd like to get us started with. And one of those concerns the question of how you came to examine this material by attending to these different areas. So you're looking at legal sources and medical sources, and you're also examining some of the printing, print sources that were more popular in their circulation. So how did you come to examine those three types of source materials, and what do you think each of them lends to more precise and sophisticated understanding of how sexual violence was treated in this context?
Well, thank you for that question. I first, it happened when I was working on an article on Little Red Riding Hood way back when I was a graduate student, that when I taught the tale to my students and they found an impressive bibliography, I started reworking that short story. And I could never understand why in the French version of the story, there are two murders or rapes of the grandmother in Little Red Riding Hood. And we blame Little Red Riding Hood for what befalls her instead of the perpetrator. So I could understand the misogyny, but I couldn't understand how a civilizing tale could condone murder by anyone in society. And at that same time, Georges Vigarello, who's a sociologist in France, published History of Rape. And in there, he said that rape was considered a heinous crime, but one that was tolerated. And that set off a light bulb. And in his work, he had some of these canards sanglants from the earlier century. Move forward 8-10 years, and I had a colleague who was putting together a seminar series in France on gender and the press. And she just haphazardly asked me, do you have anything on this topic? And I said, well, I worked on these sensationalized newspapers. I can see if there are any that exist in the 19th century. And that's what got me going down this path of the canards sanglants. And my Little Red Riding Hood article analyzed that tale in function of French jurisprudence. And so I have always found that in part that the law and these sensationalized newspapers come together and reinforce each other. In 17th century and 18th century, a violent act was written as something erotic. The perpetrator was defined sometimes in French law as a lover. The victim was blamed for what happened to her. In the 19th century, there's a shift. And the medical reports, that's just doing my archival research. I came upon one or two medical reports on the topic of rape when I was searching for my corpus, and I found over a dozen. And what I find where they coincide is in some sensationalized language, in some self-censorship. They all say this is so heinous of a crime. My pen refuses to write the details. But what happens is, not that we want to read those details, they're brutal, and the medical reports are the worst because it documents in a detailed manner every wound, and they're manuals for future practicing doctors. So how to approach the exam are in these works. But I just lost my train of thought.
Well, we have a question that's related.
Okay.
Go ahead.
Well, I was just going to say that when you don't bring in the victim's voice, there is erasure a third time.
And there's a question very much related to what you're talking about right now. It's what you find as you move from one type of source to the other. And so one of our attendees was asking how you might characterize the differences in representation of rape in archival and legal documents on the one hand, and other types of literature, for example, novels, that were also part of the same period. So how would you characterize those different ways of portraying?
There are multiple ways. In novels, for example, and in painting, often the rape is obfuscated by metaphorization. There's a blurring of rape and rapture where you might have a satire taking a woman and her head is tilted back like she's in ecstasy, but he's clutching her hard. Or you have a head tilted back, which was in a white body, which was the artistic way of depicting nudes at the time, but the body was inert. So I always read counter the dominant way these stories are told. So there's either blurring of the boundaries, a metaphoricity of rape, where it could be, but we're not sure. In the penny presses, they also do not represent the crime, but you have little snippets of the medical report. And that's what is hard to read. They are the most have the greatest narrative flair, if we can say that, where they rely on typical narrative devices of suspense and horror and melodrama, because often, sadly, in my corpus, most of my victims are young children. So they not only relate the crime, but they show the village's response to the criminal and the parents crying for their child. And so it's really meant to move audiences, the readers of them. And in French law, believe it or not, there can be similar narrative strategies, like I was saying, where there's a courtly love trope of the perpetrator seeing the woman and falling in love with her, and that dismisses the brutality of the crime. So it really depends on the genre that you're looking at sometimes.
Okay. Well, another viewer is asking about the prosecution of the case in cases that you shared with us. They're saying that it's important, they're aware that we should keep in mind that most rape cases were not prosecuted, which is not entirely dissimilar to today. And lots of cases of sexual assault never go prosecuted. So why do you think the cases that you've been looking at were prosecuted? What may have led to them being brought to attention? And then there's a related question here about people who were nobility, did they tend to be tolerated and not prosecuted as well?
Sure. And the priests. Well, for Contrafatto's trial, it really was a celebrity crime, and I would suspect that it was the penny presses and the broadsheets that made it known,
Mm.
and the court, because these are like the first soap operas before soap operas existed, or the feuilleton, as we say in France, where you have a novel and you break it up in little bits and you publish a chapter at a time. They did the same thing to keep the public interested in the storyline. Later, for example, there's another case called the Flavian affair in the late 1880s rather. And that also involved a priest and a 12-year-old boy, and they were not sure if the priest murdered this young boy and also sexually assaulted him, but it folded into two phenomena at the time: religious anti-clericalism and the Dreyfus affair, where positions were being hardened. You know, either you're for the priest or you're against the priest. You're for private Catholic schooling or you're not. And Catholic schooling was on its way out in the latter part of the century. So I think in the earlier part of the century, it is coincidence, perhaps, because I haven't found other rape cases, trials, that is. And later in the century, it's because it dovetails with anti-clericalism and it allows the state to make a case against religious teaching.
We have another question from one of our
These are great. Thank you.
who's asking about young boys. So you did mention that the overwhelming majority of these cases were very young people.
Mm-hmm.
And you, in one of your slides very early on, showed that most of these were girls.
Mm-hmm.
But there's a question here: were young boys subjected to rape, and how was this perceived? And then there's a little further question as well on what would constitute a more precise understanding of rape with such categories of assault and penetration in mind.
I'm trying to remember. Well, sodomy appeared under rape. And in examples of rape, they also mention that it could happen to boys or girls. So it was always an inclusive term, children. And there wasn't a separate legal category. It was a medical doctor who brought sodomy to the public's attention. And he said, you know, I don't want to write on this filthy topic. And I'm quoting, but given the recent murders, because there was another murder that had happened, and it was a male, there was a series of murders of men who were also raped. And the doctor was very troubled by this and went about examining victims in this category. So that was in the mid 1850s, but it was considered filth. It was against nature. I mean, my chapter on this issue of pedophilia, the word pedophilia in French in the 19th century meant many things. It meant pedophilia, as we know, crimes against minors. It meant male prostitution, homosexuality. So there was a blurring of all those categories as well. And my case has a troubling canard sanglant that I didn't see reported on in the elite presses, that I first did not include in my corpus. And then I wrote an article. It's like, I'm going to include these series of canard sanglant because you have a man that was buried alive, so to speak. So this is it can be fact or fiction, and this is sort of the fictive element of it. But when they found the body, the male was completely nude except for a shirt. And they didn't ask any questions. And I was so troubled by that it stayed with me for many years. And I eventually wrote on it. So that's one of the only examples I have of what I state as male rape.
And one other related question here is the distinction between a child and a woman. And you might speak more broadly to adult as well. But how do those distinctions get made? What actually constituted the dividing line between someone being classified as a child versus adult, and girl goes to woman?
Well, again, the paper was a close reading, so you're not going to keep all those dates straight. But between the late 1700s and the last 2/3 of the 19th century, the age of majority for minors changed from 15 to 11 to 13. So it was up, it went down, and then it went slightly back up again. For women, there were several distinctions. There were virgin women, and that's sometimes the only case that they would consider as a rape case if the woman was a virgin, and hence the importance of the medical reports that the doctors authored. And these are after 20, 30 years of experience, and they present actual cases that they examined. You have the case of women that were married or had sex before, and prostitutes could be raped as well. But when the kind of adult woman that was sort of set aside was she who had sexual relations and was not married.
And what do you mean by set aside? Because you said that someone who's a sex worker could be recognized as a victim of rape. So they would be someone who was not married and had sexual relations. So yeah,
it's a contradiction, isn't it?
Right.
Yeah, but they do make a separate case in these medical reports about different ages of women and the exam and to what degree we can believe them or not. And as I said, they often were not believed, which makes this case so amazing.
Yeah. Well, we have just a couple of minutes left, but there's one other question here asking what your plans for research are after publishing the book. When the book is done, is this something that you plan to continue investigating, or do you have other plans for your research beyond the book?
Yeah, no, thank you for that. No, I will move from rape because I've worked on it off and on for over 20 years, and I want to get back to my first book was on representations of bourgeois women in literature, art history, and private diaries. And I began to work on working women. And then I got sidetracked on this project. So I would like to get back to working women. I've published 2 articles on this topic, and it would bring me great pleasure to discover. I'll be doing similar work because there was blurring of boundaries between prostitutes and working women. If you were out in public without being accompanied, you were considered a prostitute, and that's what working women did. So some of those discourses will overlap, but I'm looking forward to a change of topic. It's not a good conversation at the dinner table.
Yeah, this is very difficult material, but also very important material.
Important, yeah.
And we are very grateful that you have taken time to share your research with us. So thank you again.
Well, thank you, Sylvester, for offering this opportunity to have research associates.
Absolutely. And I want to thank all of those of you who joined us today to listen to Sharon discuss her work with us. We'll see you next time in our faculty colloquium. So thank all of you again. Thank you.
Bye-bye.